5 seconds to go. Start. In the present case, the importance of the decoding registers was raised in the examination of PW41. Stop. Accordingly, the decoding registers merely being additional documents required to be able to appreciate the existing evidence in form of the call details which are already on record, but use codes to signify the location of accused, a crucial detail, which can be decoded only through the decoding registers, the right of the accused to a fair trial is not prejudiced. Stop. The production of the decoding registers fits into the requirement of being relevant material which was not brought on record due to inadvertence. Stop. Para. Finally, we also briefly deal with the objection of the respondents regarding the stage at which the application under section 311 was filed. Stop. The respondents have placed reliance on Swapan Kumar Supra, a two-judge bench decision of this court, to argue that the application should not be allowed as it has been made at a belated stage. Stop. The court in Swapan Kumar Supra observed, para, bracket start, it is well settled that the power conferred under section 311 should be invoked by the court only to meet the ends of justice. Stop. The power is to be exercised only for strong and valid reasons, and it should be exercised with great caution and circumspection. Stop. The court has wide power under this section to even recall witnesses for re-examination or further examination, necessary in the interest of justice, but the same has to be exercised after taking into consideration the facts and circumstances of each case. Stop. The power under this provision shall not be exercised if the court is of the view that the application has been filed as an abuse of the process of law. Stop. Para. Where the prosecution evidence has been closed long back and the reasons for non-examination of the witness earlier are not satisfactory, the summoning of the witness at belated stage would cause great prejudice to the accused and should not be allowed. Stop. Similarly, the court should not encourage the filing of successive applications for recall of a witness under this provision. Stop. Bracket close. Para. In the present appeal, the argument that the application was filed after the closure of the evidence of the prosecution is manifestly erroneous. Stop. As already noted above, the closure of the evidence of the prosecution took place after the application for the production of the decoding register and for summoning of the witness under section 311 was dismissed. Stop. Though the dismissal of the application and the closure of the prosecution evidence both took place on 13th November 2021, the application by the prosecution had been filed on 15th March 2021, nearly 8 months earlier. Stop. As a matter of fact, another witness for the prosecution, Rajesh Kumar Singh, was also released after examination and cross-examination on the same day as recorded in the order dated 13th November 2021 of the trial court. Stop. Para. The court is vested with a broad and wholesome power, in terms of section 311 of the CRPC, to summon and examine or recall and re-examine any material witness at any stage, and the closing of prosecution evidence is not an absolute bar. Stop.